1.
Well, before I pick up the thread from yesterday, may I show to your lordships the Odisha Act also? The provisions of the Odisha Act.
Would like to mention item number 901.10 and
Not now. Just circulate an email. I'll accommodate your mentioning request.
But just one before the, for oil, I'm the last batsman, item 26, for oil companies. I'm the only part for the oil companies.
On this side or this side?
This side.
On this side, yes.
This side. Yes. We are saying that our point is India Cements is not a typographical, that's point
Right.
taken. And for us, more important thing is the Assam government is levying a tax on the crude extracted. So that the Assam government has the power to levy tax under entry 49.
We'll hear you. We'll hear you after all.
I've given the two questions.
Yes.
So volume 4, my lords, at page 3179. Kindly have section 3. Levy of tax. On and from the commencement of this act, there shall be levied and collected a. I'm sorry. Lost you have?
179.
Hello, Justice Mishra has one?
Yes.
On and from commencement of this act, there shall be levied and collected a rural infrastructure and socio-economic development tax on all mineral-bearing land in the manner hereinafter provided. For the removal of doubt, it is hereby declared that any land which is subject to levy of tax under subsection 1 shall not be liable to cess under Odisha Cess Act 1962. The rural infrastructure and socio-economic development tax shall be levied annually on all mineral-bearing land at such rate not exceeding 20% of the annual value of such mineral-bearing land, as the state government may by notification fix in that behalf, and different rates may be fixed for different mineral-bearing land, provided that where in the case of any mineral-bearing land there is no production of mineral for 2 consecutive years or more, such land shall be liable for levy of tax at such rate not exceeding the dead rate payable under the law for the time being in force on that mineral-bearing land as may be prescribed. Provided further that the state government shall notify the rule of tax in respect of any such mineral-bearing land once during any period of 2 years. And 3, the state government, before fixing the rate, shall appoint a committee in such manner as may be prescribed, who shall recommend to the state government the annual value of mineral-bearing lands and the rate at which the tax may be levied. Every notification shall be laid before the state legislature for 14 days. If your lordship reverts to section 2A, is the annual value of mineral-bearing land defined in relation to a financial year means 1/2 of the value of mineral produced from mineral-bearing land during the 2 years immediately preceding that financial year. The value of mineral-bearing being that as could have been fetched by the entire production of mineral during the said 2 immediately preceding years. Had the owner of such mineral-bearing land sold such mineral at the price or prices, excluding the amount of tax, fee, duty, royalty, or any other amount as may be prescribed that prevailed on the date immediately. See, explanations, are not important. The aspect which I wish to highlight is that this excludes, unlike what was being considered in India cement, where land revenue royalty was brought in. Here all taxes of all kinds have been excluded. And not the total value, but 1/2 of the value is being taken note of. So that scenario of cess on royalty, which my learned friend Mr. Salve had said that it's the cess on royalty, and since I'm agreeing, therefore, that his matter stands covered by that concession. Although concession doesn't decide, but the two provisions are completely different. This is not a cess on royalty at all, not even a component. Now coming back, to I had shown to your lordships Odisha Cement, where this error issue had been pointed out, but the court did not go into it. The other case, in which this issue of the contradiction in para 34 was raised is Mahalakshmi Fabrics. I'm just giving the reference. I'm not citing because submissions have been made. I'll just give the reference. (1995) Supplementary 1 SCC 642 State of MP versus Mahalakshmi Fabric Mills, and that is at page 1567.
Volume 4.
Yes,
Volume 5.
Volume 5. I'm sorry, volume 5.
1567.
Now, in this case, Justice Kuldeep Singh wrote the judgment, and he cursorily rejected it, relying upon India Cement, and said that he doesn't think that there is an error. Then, it was again raised in Keshav Ram. Finally, it was left to Keshav and Ram to combine to correct the error.
Where do we get Kesharam?
This is volume 5, page 2020. And when Keshav and Ram both are there, the Solicitor General is stopped from
saying anything contrary.
They have not left a place for you on that side, Solicitor.
Yes,
this place. I want him to come this side.
I am always with you.
Because their slogan, the slogan of the Prime Minister is a double engine Sarkar. So therefore,
There is a Lakshman in the bench. In the bench, there is a Lakshman.
although the Prime Minister, the Honorable Prime Minister uses that expression in the sense of government of the same party, in the party politics sense, but in the constitutional sense also we have cooperative federalism. So therefore,
Two lists is a evidence of cooperative federalism, that certain things are left to center things are left to assembly, etc. It is a
Of course, now GST has taken it to a different level altogether.
different level. That's
Or at least in theory.
and mostly in practical also, but there are certain issues, doubtlessly.
But also an aspect of cooperative federalism.
so there were number of the acts of a number of states were involved in this case. I just want to show Manoj at page 2085. In fact, section 4 begins from 2084 bottom. All immovable property to be liable to road cess and public works cess from and after the commencement of this act in any district or part of a district, all immovable property situated therein except as otherwise in section 2 provided shall be liable to the payment of a road cess and a public works cess. Section 6, next page, is how to be assessed. The road cess and the public works cess shall be assessed A in respect of lands on the annual value thereof, B in respect of all mines and quarries on the annual dispatches therefrom, and C in respect of tramways, railways and immovable property on the annual net profit thereof, ascertained respectively as in this act prescribed. And the rates at which cesses respectively shall be levied for each year shall be determined for such year in the manner in this act prescribed, provided that 1. The rates of such road cess and public works cess shall not exceed 6 paisa and 25 paisa respectively on each rupee of such annual value. 2. The rates of each of the such road cess and public works cess shall not exceed 50 paisa on each ton of coal, minerals and sand of such annual dispatches. And 2. 6 paisa on each rupee of such annual net profits. If your lordship will come down to this explanation, which says for the purposes, there's another act also, West Bengal Primary Education Act 1973, identically word, phrase, words. Then explanation at the bottom, for the purpose of clause B, the expression value of coal shall mean in the case of dispatch of coal as a result of sale thereof, the prices charged by the owner of coal mine for such coal, but excluding any sum separately charged as tax, cess, duty, fee or royalty for payment. Actually, the Odisha Act was not drafted in accordance with this after the lordships upheld this. Then they altered their own act accordingly. And that's how that stands.
That's in the West Bengal Act, right?
Yes. And the next page 2086, you shall find the West Bengal Rural Employment and Production Act 1976. And you shall find the similar kind of an explanation there also. That's placitum E. Now kindly come to para 33. As regards the state of UP, it's 2097 is the page where they have quoted the provision. But kindly come to para 33 at page 2102. We now proceed to enter a deeper dimension in the field of tax legislation by considering the problem of devising the measure of taxation. This aspect has been dealt with in detail in Union of India versus Bombay Tire, tracing the principles from leading authority of a reference under the Government of Ireland Act and Section 3 of the Finance Act, passing through Ralaram versus Province of East Punjab, and treading through the law as it has developed through judicial pronouncements one after the other. This court has made subtle observations therein. It has been long recognized that the measure employed for assessing a tax must not be confused with the nature of the tax. A tax has two elements. First, the person, thing or activity on which the tax is imposed, and second, the amount of tax. The amount may be measured in many ways, but a distinction between the subject matter of a tax and the standard by which the amount of tax is measured must not be lost sight of. These are described respectively as the subject of tax and the measure of tax. It is true that the standard adopted as a measure of the levy may be indicative of the nature of the tax, but it does not necessarily determine it. The nature of the mechanism by which tax is to be assessed is not decisive of the essential characteristic of the particular tax charge, though it may throw light on the general character of the tax. Then the lordships have referred to these various judgments. And we have para 38. In Hingir Rampur Coal Limited, the form in which the levy was imposed was held to be an impermissible test for defining in itself the character of the levy. It was argued that the method of determining the rate of levy was by reference to the minerals produced by the mines, and therefore it was a levy in the nature of duty of excise. This court held that the method thus adopted may be relevant in considering the character of the impost, but its effect must be weighed along with and in the light of the other relevant circumstances. Referring to Bombay Tire, the court further held that it is clear that when enacting a measure to serve as a standard for assessing the levy, the legislature need not contour it along lines which spell out the character of the levy itself. A broader based standard of reference is permissible to be adopted for the purpose of determining the measure of the levy. Any standard which maintains a nexus with the essential character of the levy can be regarded as a valid basis for assessing the measure of the levy. Then the lordships have gone on to this section, entry 49 lists to what is the scope. I'll read Milord's para 40. Ample authority is available for the concept that under entry 49 in list 2, the land remains a land without regard to the use to which it is being subjected. It is open for the legislature to ignore the nature of the user and tax the land. At the same time, it is also permissible to identify for the purpose of classification the land by reference to its user. While taxing the land, it is open for the legislature to consider the land which produces a particular growth or is useful for a particular utility and to classify it separately and tax the same. Different pieces of land identically situated otherwise but being subjected to different uses or having different potential are capable of being classified separately without incurring the wrath of Article 14 of the Constitution. The Constitution bench in Kunhat Mopal Nair versus State of Kerala held that the land on which a forest stands is not to be excluded necessarily from entry 49. The erstwhile entry 19 of list 2 applied to forest. The lordships held that the use of the word forest in entry 19 could not be pressed into service to cut down the plain meaning of the word land in entry 49. In Ajay Kumar Mukherjee versus Local Board of Barpeta, the appellant, a landholder held a hut or a market on this land. The local board asked the appellant to take out a license and pay rupees 600, later rupees 700 by way of license fee for holding the market. It was urged that the impost was unconstitutional interiorly on the ground that the tax was actually imposed on the market, which infringed Article 14 of the Constitution, and also because the state legislature had no legislative competence to tax a market. The local board relied on entry 49 in list 2. The appellant urged that entries 45 to 63, which deal with taxes, do not contemplate a tax on markets. Repelling the plea, the Constitution bench held that the tax was on the land, though the charges arise only when the land is used for market. The tax remained a tax on land in spite of the imposition of being dependent upon the user of the land as market. The tax was an annual tax as contrasted to a tax for each day on which the market was held. The owner or occupier of the land was responsible for payment of tax on annual basis. The amount of tax depended upon the area of the land on which the market was held and the importance of the market. Thus, the tax was held to be a tax on land. Then kindly have 42. Once it is held that the land or building is available to be taxed, it does not matter to what use the land is being subjected, though the nature of the user may enable land of one particular user being classified separately from the land being subjected to another kind of user. The tax would remain a tax on land. It cannot be urged that what is being taxed is not the land, but the nature of its user. So also it is permissible to adopt myriad forms and methods of valuation for the purpose of quantifying the tax. In Ralaram, the federal court made it clear that every effort should be made as far as possible to reconcile the seeming conflict between the provisions of the provincial legislation and the federal legislation. Unless the court forms an opinion that the extent of the alleged invasion by a provincial legislature into the field of the federal legislature is so great as would justify the view that in pith and substance the impugned tax is a tax within the domain of the federal legislature, the levy of tax would not be liable to be struck down. The test laid down in Sir Byram G. Jijibhoy's case by the full bench of the Bombay High Court was approved. In Assistant Commissioner of Urban Land Tax, Buckingham and Karnataka Company, for the purpose of attracting the applicability of entry 49 in list 2, so as to cover the impugned levy of tax on land and buildings, the Constitution bench laid down twin tests, namely that such tax is directly imposed on lands and buildings, and two, that it bears a definite relation to it. Once these tests were satisfied, it was open to the state legislature for the purpose of levying tax to adopt the annual value or the capital value of the lands and buildings for determining the incidence of tax. Merely on account of such methodology having been adopted, the state legislature cannot be accused of having encroached upon entry 86, 87 or 88 of list 1. Entry 86 of list 1 proceeds on the principle of aggregation, and tax is imposed on the totality of the value of the assets. It is quite permissible to separate lands and buildings for the purpose of taxation under entry 49 in list 2. Now, this is quite very important, Lord, because this property may be same. In one case, it is aggregated with other assets, the federal legislature is in the parliament taxes. But if it's separate, then state under 49. And nobody can say that it's the same property included there and the same property which is being taxed under 49. Because the subject matter is different. And that's how the division of taxing power has been done. Then in 45 also, in RR engineering, I'm leaving the rest of para 44, is a case of circumstances and property tax levied on the basis of income which the assessee receives from his profession, trade, calling or property. The plea that the tax was a tax on income was discarded. The test propounded by the Constitution bench is that an excessive levy on circumstances may tend to blur the distinction between a tax on income and a tax on circumstances. Income will then cease to be a measure or yardstick of the tax and will become the very subject matter of tax. Restraint in this behalf is a prudent prescription for the local authorities to follow. The Constitution bench observed that it was only a matter of convenience that income was adopted as a yardstick or measure for assessing the tax, and the evolvement of such mechanism was not conclusive of the nature of tax. Now, this again is very significant because income tax is directly on income, and the haisiyat kar, as we say, or the circumstances tax, that can also be having a measure which is based on income. We are inclined to make a reference to a few selected full bench decisions. I am leaving these words. Lordship may just have 47, which is Byram G, which is consistently referred to by the Constitution benches, a full bench of Bombay High Court. The provincial government levied a tax at the rate of 5% of the annual letting value in the city of Bombay on the buildings and lands. The buildings were classified by reference to their annual letting value. An exception from payment of tax was also carved out in favor of such buildings as remained vacant and unproductive of rent for the specified period. It was urged that the impugned tax purported or desired to tax the value, placing reliance on the federal court's decision CP Motor Spirit Act 1938. Chief Justice Beaumont held that the impugned tax was a tax on land and buildings. 3 submissions were made in support of the challenge. 1, that the tax is graded by reference to the annual value of the property charged. 2, that an allowance was available to be made in respect of vacant properties. And 3, that the basis of the tax was the same as the basis on which tax on income from property was imposed by Section 6, and in reality the rate was a tax on income. Chief Justice held that the regard must be had to the pith and substance of the impugned tax and not merely to the form. all the items of the in the provincial list must be so construed as to exclude taxes on income. The tax is charged on lands and buildings, and it is based on the estimated rent which the property would fetch. Such a value may bear very little relation to the actual income of the property. It is imposed without any relation to the capital value except insofar as such value can be ascertained by reference to the rateable value. It did not make any difference if the arbitrary basis which was adopted for the purpose of the rate might as well be applied for ascertaining the capital value as for ascertaining income. The fact that some concession is allowed to the small owner, a concession which may be based as much on political as on economic considerations, and that an allowance may be made where the property is shown to produce no income, a fact which may be taken to show that the estimated value was found to be erroneous, cannot alter the nature of the tax. The concept that in the case of conflict between the federal list and provincial list, an entry in the federal list may be given a more restricted meaning was endorsed, the legality of the levy was upheld. Now, this is not a very classification, Malad, is permissible under Article 14. And I'm emphasizing this part of it where it says that if a property is not earning any rent and is lying vacant, and the legislature says we don't need to tax it because the owner is not earning anything. So that's a valid classification. Otherwise, if we just in the case of farmers also, land revenue, this is a recurrent grievance of the farmers that because of vagaries of nature, the crop has failed or they have not been able to obtain sufficient crop yield, then it should be exempted. So all those methodologies are available. Either you exempt in the beginning by the law or you exempt later on or have a provision of exemption. So these are various methodologies available to the state. And if we don't adopt this methodology, then we...
In fact, para 50 specifies that aspect, that though the constitution has created a federal structure with a slight balance in favor of the center,
Yes.
while interpreting the different entries, the court must ensure that the powers of the states
Yes,
to impose taxation are not whittled down or they're not abrogated.
that's right. So unless there is compelling language, plain language, which makes us yield the power in favor of federal legislature or the parliament, the effort should be more, because as it is, the states are weak and gradually there is more and more erosions happening.
Just see para 50 placitum D. True, the center has been given more powers.
True, the center has been given more powers, but the same is accompanied by certain additional responsibilities as well. The Constitution is an organic living document. Its outlook and expression as perceived and expressed by the interpreters of the Constitution must be dynamic and keep pace with changing times. Though the basics and fundamentals of the Constitution remain unalterable, the interpretation of the flexible provisions of the Constitution can be accompanied by dynamism and lean in case of conflict in favor of the weaker or the one who is more needy. Several taxes are collected by the center and allocation of revenue is made to the state from time to time. The center consuming the lion's share of revenue has attracted a good amount of criticism at the hand of states and financial experts. The interpretation of entries can afford to strike a balance, or at least try to remove imbalance, so far as it can. Any conscious whittling down of the powers of the state can be guarded against by the courts. Let it be said that federalism in the Constitution is not a matter of administrative convenience, but one of principle, the outcome of our own historical process and a recognition of the ground realities. Quoting from Shri M.C. Sitalwad, Justice Jeevan Reddy observed, it is enough to note that our Constitution has necessarily a state bias towards center vis-a-vis states. It is equally necessary to specify, to emphasize that courts should be careful not to upset the delicately crafted constitutional scheme by a process of interpretation.
Then para 51 onwards, they deal with India Cement. So we can look at that actually, because that's the
That's the
key.
relevant one.
Here, your lordships may note that this aspect has been also, Lord, emphasized in Jindal Steel.
Page 108 of written submission, you've given the extracts.
That is on part 13, right?
Yes,
Article
at page
301.
108, your lordship, in note of my written submission, we have extracted that portion. Yes, I'm grateful to my learned friend. If your lordship have para 47, just above para 48, the same idea is,
This really,
yes.
Said that it is.
The concept that in case of conflict between federal list and provincial list, an entry in the federal list may be given a more restricted meaning was endorsed. The legality of the levy was upheld. That is in Byramji.
let's look at para 52 onwards, India Cement, and then
Yes.
going to para 60.
What was impugned was a levy of cess on royalty, and the question was whether such cess on royalty is within the competence of the state legislature. The appellant was required to pay. This is all the act, reference to the act and the entries involved. Then in para 53, the lordship refers to. It will be better if the lordship has from para 54, where Lakshmi
Yes.
Narayan's case of Mysore High Court is dealt with, and then they come to the royalty if tax. A division bench decision of the Mysore High Court in Lakshmi Narayan Mining Company and versus Taluk Board was cited with approval in India Cement. The Mysore High Court struck down as violative of the MMRD Act 1957, a license fee on mining manganese or iron ore, etc. of the MMRD Act imposed by state legislation. A perusal of the judgment of Mysore High Court shows that the impost was by way of license fee on the mining of certain minerals. The regulation and development of mines and minerals were undertaken by the central legislation, and therefore the power of the state legislature under entries 23 and 52 list 2 got denuded in the field of regulation and development covered by the central legislation. The division bench provides page 301, para 6, it is therefore clear that to the extent the Central Act makes the provisions regarding regulation and development of minerals, the powers of the state legislature under entry 23 list 2 stands curtailed. The state government had sought to defend the license fee on the ground that it was in the nature of tax and not a license fee. This plea has been specifically noted by the High Court and dealt with. However, what is significant to note is the revelation made by careful reading of the judgment that provision of license fee was made in the central legislation, and the license fee was thought to be imposed by the state too. In fact, the license fee was a step trenching upon the field of regulation and therefore was liable to be struck down on this ground alone. Yet another reasoning which prevailed with the High Court was that Section 143 of the State Act, which was not inconsistent with the Central Act, was relied on by the state government as conferring power on it to levy the impugned license fee. On what plea the High Court formed, on that plea the High Court formed an opinion that on the framing of Section 143 of the State Act, it did not in express terms authorize a levy of fee or a tax. So the state had no delegated power to impose a tax. So on two grounds, the High Court observed it cannot also be construed as conferring such a power on the respondents to levy a tax or fee on mining in view of the well-settled rule of statutory construction that a court construing a provision of law must presume that intention of the authority in making it was not to exceed its power but to enact it validly. The ratio of the decision of the Mysore High Court is that the provision for licenses and license fees operating in the field of regulation of mines and minerals is not available to be made by the state legislation in view of the declaration in terms of entry 54 list 1. In our view, the decision of the Mysore High Court cannot be read so widely as laying down the law that union's power to regulate and control results in depriving the states of their power to levy a tax or fee within their legislative competence without trenching upon the field of regulation and control. there is a distinction between the power to regulate and control and the power to tax, the two being distinct, and the difference has not been kept in view by the Mysore High Court. So actually, my lord, that other part was not really necessary because license fee was challenged. They held it is fee, and therefore, and there was no power also, which was sufficient ground. But
And the Central Act had a specific provision for a license.
that's it. But the state said then, as it happens, my lord, that when we start falling back on
Alternate
other
dates and
things,
making alternative, alternative grounds of
submissions are
defense.
always dangerous. So they said it's tax. So then, my lord, the fault was really with the judgment of Justice Vanchu, my lord, in Hingir Rampur, which is though concurring, but this judgment is it alone goes into. I'll show that judgment. It's a dissenting judgment. So because of that, my lord, being at the level of High Court, his lordship as he then was. So naturally had to, my lord, look at that.
Para 56,
Justice Vanchu.
Justice Lauti as he then was. Justice
Yes,
Lauti in
we
para
would-
56 begins it very beautifully, you know.
We would like to avail this opportunity
Yeah, print.
for pointing out an error attributable either to the stenographer's devil or to sheer inadvertence having crept into the majority judgment in India Cement Limited case. The error is apparent and only needs a careful reading to detect. We feel constrained, rather duty bound to say so, lest a reading of the judgment containing such an error, just an error of one word, should continue to cause the likely embarrassment and have adverse effect on the subsequent judicial pronouncement which would follow India Cement, feeling bound and rightly by the said judgment having the force of pronouncement by a 7-judge bench. Then they quote para 34 and they italicize the two observations in the first and last sentence. Para 57, in the first sentence, the word royalty occurring in the expression royalty is tax is clearly an error. What the majority wish to say and has in fact said is cess on royalty is a tax. In place of royalty only, the words cess on appear to have been inadvertently or erroneously omitted while typing the text of the judgment. This is clear from the reading of the judgment in its entirety. While paras 22 and 31, which precede para 34 above said, their lordships have held that royalty is not a tax. Even the last line of para 34 records royalty on mineral rights is not a tax on land but a payment for the user of the land. The very first sentence of the para records in quick succession, as such, a cess on royalty being a tax on royalty is beyond the competence of the state legislature. What their lordships have intended to record is that cess on royalty is a tax, and as such, cess on royalty being a tax on royalty is beyond the competence of state legislation. That makes correct and sensible reading. A doubtful expression occurring in a judgment apparently by mistake or inadvertence ought to be read by assuming that the court had intended to say only that which is correct according to the settled position of law, and the apparent error should be ignored. Far from making any capital out of it, giving way to the correct expression which ought to be implied and or necessarily read in the context, also having regard to what has been said a little before and a little after. No learned judge would consciously author a judgment which is self-inconsistent or incorporates passages repugnant to each other. While para 22, their lordships have clearly held that there is no entry in list 2 which enables the state to impose tax on royalty, and therefore the state was incompetent to impose such a tax. The cess which has incidence of an additional charge on royalty and not a tax on land cannot apparently be justified as falling under entry 49 list 2. It is of significance for the issue before us to determine the nature of royalty and whether it is a tax, and if not, then what it is. Until the pronouncement of this court in India Cement, it has been the uniform and unanimous judicial opinion that royalty is not a tax. Then your lordship will see the consideration given by the court to the meaning of royalty. We first refer in para 59 to the dictionary meanings.
Para 60 is important.
Para 60, I'm leaving that.
They have referred to DK Trivedi.
That's right. In DK Trivedi, A bench of two learned judges of this court dealt with rent, royalty, and dead rent and held as follows. Rent is an integral part of the concept of a lease. It is the consideration moving from the lessee to the lessor for demise of the property to him. In mining lease, the consideration usually moving from the lessee to the lessor is the rent for the area leased, often called surface rent, dead rent, and royalty. Since the mining lease confers upon the lessee the right not merely to enjoy the property as under an ordinary lease, but also to extract minerals from the land and to appropriate them for his own use or benefit. In addition to the usual rent for the area demise, the lessee is required to pay a certain amount in respect of the minerals extracted, proportionate to the quantity so extracted. Such a payment is called royalty. It may, however, be that mine is not worked properly so as not to yield enough return to the lessor in the shape of royalty, in order to ensure for the lessor a regular income regardless of whether the mine is worked or not. A fixed amount is provided to be paid to him by the lessee. This is called dead rent. Dead rent is calculated on the basis of an area leased, while royalty is calculated on the quantity of minerals extracted or removed. Thus, while dead rent is a fixed return to the lessor, royalty is a return which varies with the quantity of minerals extracted or removed. Since dead rent and royalty are both a return to the lessor in respect of the area leased, looked at from one point of view, dead rent can be described as the minimum guaranteed amount of royalty payable by the lessor. At the bottom in HRS Murthy, to the Constitution bench of this court had defined royalty to mean the payments made for the materials and minerals won from the land. In para 61, the various high courts are referred to. A full bench of the High Court of Odisha held in Lakshmi Narayan Agarwal. Royalty is the payment made for the minerals extracted. It is not a tax. In Suraj Deen Lakshman Lal versus State of MP Nagpur, a division bench of the High Court of Madhya Pradesh referred to Wharton's law and Mosley and Whiteley's dictionary. Royalties are payments which the government may demand for the appropriation of minerals, timber, or otherwise belonging to the government. The High Court opined that there are two important features of royalty. The payment is in proportion of the quantity removed, and the basis of payment is an agreement. Then drawing a distinction between royalty and tax, a division bench of the High Court of Punjab and Haryana held in Shanti Swarup Sharma, Dr. Shanti Swarup Sharma versus State of Punjab. If a person is merely in occupation of land which contains minor minerals, he is not liable to pay any royalty, but it is only when he holds a mining lease and by virtue of that extracts one or more minor minerals that he is called upon to pay royalty to the government, where the lease is in respect of the land in which minor minerals vest in the government. Royalty thus has its basis in the contract for payment to the owner of the minerals for the privilege of extracting minor minerals, computed on the basis of quantity actually extracted and removed. It is more akin to rent or compensation payable to an owner by the occupier or lessee for its use or exploit of the resources contained therein. Merely because the provision with regard to royalty is made by virtue of the rules relating to the regulation of the mining lease and a uniform rate is prescribed, it does not follow that it is compulsory exaction. They refer to the Gujarat High Court. And if I may say so with respect
Royalty is paid for the exercise of mineral rights.
Yes.
And mineral rights could be taxed under entry 50 by the state government. But in the interest of mineral development, the list 1, which speaks of mineral development, wants to have a uniformity insofar as payment of royalty is concerned throughout the country. Therefore, it is taken as part of list one, and it is a limitation on the exercise of the state to impose any limit royalty as per entry 50 of list
So
two.
we can't,
That is one way of looking at it.
so,
Or it is a tax in a way, but coming under the MMRD Act and under entry 54 of list one.
oh, I would submit, Milord, that a
Rise of
tax
Dr.
by itself is sovereign exercise, which is not correlatable to
Or
any
you can call it an impost.
imposed also under 366(28) is clubbed with tax. And it's a part of a definition of taxation. So we can't understand imposed as far removed, something different, Milord, completely from
It's a
tax itself.
compulsory, it's a compulsory exaction for the
The
revenue.
doctrine of nociter associates, Milord. I mean, just as a man is known by the company he keeps, Milord, therefore the word imposed is only sort of defining taxation, including tax or imposed. And then they say, understand tax accordingly. That's what 28 is.
And even if the government is extracting the mineral from land
Yes.
which belongs to a private
Private
party,
person.
you're liable to pay the.
So it can't be tax.
It is, no, or an impost. Something which, it is an exercise of a mineral right, which has to be paid by the person who has got the mining lease. When he extracts the mineral, he is bound to pay the royalty.
So my respectful response is, my lord, that please understand imposed in Article 366(28) as something similar to tax. All kinds of charges which are imposed, which are in the nature of a tax, namely a sovereign need. The government needs tax money not because it is parting with its ownership of mineral, but because, Lord, it has to maintain an army, a police force, then there's a judiciary, the government itself, the foreign affairs which it has to take care of. So it needs a large amount of money for which, and for which, my lord, the government does not either it's not parting with its ownership in anything, nor, my lord, it is guaranteeing that it is going to give you something back in the sense of a quid pro quo or in a sense of a regulatory fee.
Definition also begins with the words unless the context otherwise requires.
Right. So I'm relying strongly on that expression. Therefore, this definition would not be available if the text or context, my lord, of the particular statute or other provisions of the Constitution indicate that it is not a tax.
So therefore, we have to go into the object of having royalty, which is throughout the country uniform under the Central Act.
So innate character of royalty remains the same, irrespective of whether the state government fixes it for minor mineral under Section 15, which will vary from state to state, or the central government takes that power and wants to fix a uniform royalty for major mineral. So idea of uniformity is not inconsistent with the innate character of royalty. It doesn't change that. Because as I said, this is a cooperative federalism, and if a uniformity is desired in the field of royalty for major minerals,
Yes.
which are of national importance, then the only authority, which can be trusted with this power would be the union, because one state cannot fix it uniformly for the other states. So therefore, it has been fixed. But it's royalty, therefore,
Uniformity is in
because
regard to the quantum. The uniformity is in then regard to the quantum, not in regard to the
character of the
the
levy.
character of the levy.
So it's a uniform quantity, the quantum of amount which is to be recovered from, let's say, coal. So whether coal is found in the mines in Jharkhand or Madhya Pradesh or Chhattisgarh or Odisha will make no difference. It may vary if the central government itself fixes it dependent upon the quality of coal.
It is.
But otherwise it will be, the quantum will remain same. So my submission is uniformity does not change the character. The innate character of royalty remains same.
not imposed.
Now, let's take the state as a unit, my lord. Let's, for the time being, for the sake of argument, my lord, remove the other states. Let's take the state of UP, my lord. Now, sand is a minor mineral, and under section 15, the state is empowered to fix royalty for the minor minerals. Now, the river is flowing, my lord, right from Rishikesh, my lord, right up to Varanasi and onwards into Patna, my lord, Bihar. At various points, the leases are granted for extracting sand as minor mineral. Now the state would like to have uniformity. So it's not that uniformity is only in section 9. Even under section 15, when a rule is made, the state would like to have uniformity, that is with regard to the quantum which can be realized from the sand which is recovered from the same river. Or even if the river is different, because there is Ganga, there is Jamuna, and various rivers passing through Betwa. And so therefore, uniformity, my lord, is something which is not peculiar to section 9. It is there in section 15 when the state fixes royalty. And that does not detract or alter the innate character of royalty, which is that it is a return because the state, as owner of the mineral and the land, has parted with that right. So there are various rights. At this stage itself, if I may spell out more of this mineral right, which is in entry 50.
Right, yes.
What exactly will be there in the mineral right? Justice Vanchu says, you know, that the right to extract mineral is a mineral right, but right to mineral itself is not a. Now, this is not, in my respectful submission with due deference, the learned judge. Rights which are given for extracting are under the lease. The lease is a grant under the statute. Various applicants are there. If it is auction, they'll bid. If it is otherwise, first come, first serve, whatever formula. So the lease is a grant of a leased area for the purpose of mining. There can be a lease, as we enjoy, my lords, where the government gives land for people to build houses and live, for residential purpose, for commercial purpose, various purpose. This is for mining purpose. So that is a grant of a right in the land for a particular purpose under the statute. Then under the lease which is given, you are given various rights. The first right is right to excavate, drill, or to take out the minerals in such manner as is suitable to the particular mineral. So right to excavate or drill the land. The second will be the right to extract mineral from that after excavating. So right to extract mineral is the second right. The third will be the right to beneficiate, because when you extract mineral, there is dust also coming out, there is the mineral dust also, there are lumps also. So it can't be sold like that. So they are the lessees are permitted to convert it into a suitable size, segregate it, and sell it. So therefore, that is the third right, right to beneficiate. And the fourth right is the right to carry and dispatch it for sale or sell it. They are all four rights interconnected. The whole exercise of excavating, extracting, beneficiating is meaningless unless and until Lord he sells the mineral which he has won and gets the return out of it.
But taxes on mineral rights can be levied only by the state.
By the state.
Then under what
On each of these four.
royalty is under the Central Act, we have to see.
So royalty, I have submitted that with great respect, that royalty is because of the parting of this. If the state does not part with this right by means of a lease, then the state will not be getting any of these things. So the rent, dead rent, and this, all three of them are just consideration for parting with the land and the rights to excavate, extract, beneficiate, and sell. All four of them are mineral rights, and it is the right which is taxed under. What will be the measure is a different thing, but it is the mineral right, not the right to land, right to mineral. The land which is leased and the right to mineral under the lease are two distinct phenomena, two different and distinct aspects. If I may use this expression, which is deployed in understanding the taxing entries.
Royalty cannot be a fee.
That's right. Under the lease, the mineral right will arise. My lords are right. And there are four aspects, four strands of those rights which flow from the lease. And royalty, my lords,
Share, it is a.
otherwise the lordship will have to then understand royalty when state and central government is mining in a private land and it's paying royalty, my lord, it can't be taxed, my lord, which the government is paying to the private person. Or if this partly owned by government, partly in Rule 53 says you have to.
Mr. Dwivedi, you can fortify this submission
Yes, ma'am.
by relying on Saurashtra Cement and Chemical Industries referred to in para 63
Yes.
of Kesharam.
Yes.
And these judgments are referred to in the 1990 judgment.
Yes.
Have a look.
I may place it.
Because they have said royalty may not be a fee also.
But it is not a
Not a
tax.
tax.
It is payment for the mineral which is removed or consumed by the holder of the mining lease. The minerals themselves, the property beneath the soil belonging to the union. When the holder of the mining lease removes these minerals or consumes them, he can do so only on payment of its price or value. Therefore, royalty is a share which the union claims in the minerals which have been won from the soil by the lessee and which otherwise belong to it. Royalty is a share in such minerals and not a tax in the form of a compulsory exaction. It is not compulsory because anyone who applies for mining lease to win minerals for being removed or consumed must pay its price. If he does not want to pay the price, he may not apply for mining lease. Royalty, which is a share of the owner of the minerals, the union, won by the lessee from the soil with the authority of the union, can never be said to be an imposition on the holder of a mining lease.
It's a consideration, not fee.
Yes.
Neither tax nor fee, but it's a consideration payable to the government.
Now look at it from yet another angle, Braj. Supposing if royalty is a tax, what is it that the state is getting for giving this right to the? If royalty is tax, dead rent is a minimum guarantee of royalty, so that is also tax. So the state government is owner of the land, state government is owner of the mineral, and it gets only the tax which is fixed as royalty, but it is getting no part of the consideration, the value, mineral value. As an owner, I am parting. Any owner, but it will be naturally to expect that he will expect a return for it. So which will then mean that the state will be entitled to ask for something extra apart from royalty in lieu of the parting of ownership rights in the land and mineral.
Then what happens when the state is the holder of the mining lease?
If the state is doing and reserving itself, then the state will not pay to itself anything. Because it is reserved, it's my land, it's my mineral, there's no question of charging.
Because section 9 of the Act, Central Act says the holder of a mining lease.
Yes.
So when the state itself.
State doesn't hold a lease, the state is reserving the land.
There is no hold lease.
Under section 17, state will reserve the land and do mining itself.
Therefore,
But there is a provision in the 17 and 17A that if the central government is mining,
yes,
then central government will be deemed to be holding a lease and it will pay royalty to the state government.
like NMDC,
Yes,
if they are mining.
that's right. Company will be different from central government. Central government will be protected from paying tax to the state government under Article 285.
Yes,
But your lordships have held that if the central government vests the lease in some company, then the company is not union. Company will have to pay. So it can't be that central government is paying tax, my lord, to central government is exempted under 285. So then, yes,
Thereafter, the court in Kesuram refers to subsequent decisions of the Supreme Court.
yes.
And then having referred to them, look at para 69 now. In India Cement.
In
this
fact,
is-
Lord, 68 quarry owners was another interesting case.
No, that is important.
Yes.
68 you can
There
read
they
out,
have said
68 and then 69.
Royalty and dead rent are integral parts of a lease. So if
Yes.
there is no lease, no question. of
Yes.
royalty.
says holder of a mining lease.
Because of India Cement and this quarry owners was a bench of 2 judges, so I was appearing, Lord, I was in great difficulty how to convince and get out of this royalty is a tax. So I said that it's a kind of a mixed thing. There is a tax also and there is a return also in that.
They therefore noticed that they tried to wriggle out of the
Wriggle
situation.
out.
It was a smaller bench.
Yes.
Royalty includes
The learned
right-
judges found it difficult to accept the concept, but tried to wriggle out of the situation by observing. Royalty includes the price for the consideration of parting of the right and privilege of the owner, namely the state government who owns the mineral. In other words, the royalty and dead rent which a lessee or
para 68.
includes the price of the minerals which are the property of the state. Both royalty and dead rent are
Are
integral
integral
parts
parts of it.
of a lease. Thus, it does not constitute usual tax as commonly understood, but a return for the consideration of the parting. So this
Yes.
is what I was saying, that if it is tax, royalty is tax, then state will be entitled to something, charge
Right.
something else.
Now see para 68.
That will be a greater disturbance in the system. Because then every state will be again left free to charge whatever it wants. So it's much better that we say that royalty is not a tax and let it be uniform. Whoever has a lease will pay the royalty. And where there is a reservation by the central government will pay. But where there is no reservation by any other authority and state government is doing, then there's no question of, because state is the owner and it itself is doing. 69, in decisions of 4 high courts holding royalty is not tax have been noted without any adverse comment. Rather, the view seems to have been noted with tacit approval. Further, the connotative meaning of royalty being share in the produce of land. And India Cement itself says, my lord, if that error is corrected, it itself says in the last sentence is share in the use of it. But for the first sentence, which we find to be an apparent error, nowhere else has the majority judgment held royalty to be a tax. How the above noted inadvertent error in India Cement has resulted in throwing on the loop line the movement of the latter case law in this point may be noticed. Then I have pointed out the Mahalakshmi and the Saurashtra Cement decision by a bench of 2 learned judges in India Cement has been quoted verbatim and dealt with in Mahalakshmi Fabric. This court noticed several dictionary meanings of royalty and also the
You can
decision.
skip that, go to 71.
Yes, yes.
3 lines.
We have clearly pointed out the said error as we are fully convinced in that regard and feel ourselves obliged constitutionally, legally and morally to do so, lest the said error should cause any further harm to the trend of jurisprudential thought centering around the meaning of royalty. We hold that royalty is not tax. Royalty is paid to the owner of land who may be a private person and may not necessarily be a state. A private person owning the land is entitled to charge royalty but not tax. The lessor receives royalty as his income, and for the lessee, the royalty paid is an expenditure incurred. Royalty cannot be tax. We declare that even in India Cement, it was not the finding of the court that royalty is tax. A statement caused by an apparent typographical or inadvertent error in the judgment of the court should not be misunderstood as declaration of such a law by the court. We also record our express dissent with that part of Mahalakshmi, which says that there was no typographical error in India Cement and that the said conclusion of royalties tax logically flows from the earlier paragraphs.
Yes. Now they go to the
15 of my written submission, I have given two subsequent judgments which hold that royalty is not a tax.
Page 38 are the High Court judgments.
Just hold down. Page 15, that is item 7 and 8. One is State of Himachal Pradesh versus Gujarat Ambuja Cement, 2005 6 SCC 499. 2005 6 SCC 499, para 44 to 46. 6 SCC 499, para 44 to 46. It's volume 5C, page 290. And the other is Indsil Hydropower
yes.
versus State of Kerala, 2021, volume 10, SCC 165, para 10, para 50 to 56, which is again volume 5C, page 381. And it has considered Jindal also in this.
The four items, but two are on page 13. Article 2.
As this,
Moved or consumed, both itself.
kindly have Article 297 for a second, Manoj, if that deals with the land and minerals in the territorial waters. Things of value within territorial waters or continental shelves and resources of the exclusive economic zone to west in the Union. All lands, minerals and other things of value underlying the ocean within the territorial waters or the continental shelf or the exclusive economic zone of India shall vest in the Union and be held for the purposes of the Union. The first thing to be noticed is that land and mineral are being separately. So the fact that tax on mineral rights is in entry 50 does not detract from, take out anything from tax on land and buildings, which is in entry 49. They are two different objects.
On the activity of mining.
That's right. Yes. Activity plus the product, which is to be extracted and sold.
Duty is permitted by.
All other resources of the exclusive economic zone of India shall also vest in the Union and be held for the purposes of Union. The limits of territorial waters, continental shelf, exclusive economic zone and other maritime zones of India shall be such as may be specified from time to time by or under law made by Parliament. So there is one area which is completely taken out from the states, and it is therefore for the central government. The central government grants a similar right to carry on any such activity to a private company, then or an international company, multinational company, then they will have to pay whatever the determinations are under the law or the lease.
Coastal state can't tax.
Yes. No.
Crude oil extracted
And
from
in
the
the
ocean bed.
I'm sorry, what?
Crude oil extraction from the ocean bed.
Generally,
So
yes,
that,
no, that sometimes on the,
this thing.
yes,
So union would be the authority.
yes. And that's why under the offshore rules of 2002, Lord, the royalty goes to the central government. Now that royalty again will not have a different character. It's because the land, etc., is vesting in the union, therefore the union parts with that and then demands. Then after that, their lordships have dealt with Sundara Ramayar.
What remains now? Of course, you would like to conclude the reading in this, so that.
Yes, I'll just quickly finish through this because I'm not reading all the paragraphs. Just
Okay.
pointing out, Your Lordship, at page 2119,
Yes.
the general, before that, there are two paragraphs dealing with the doctrine of the scheme of division of power regarding tax.
That is Sundaramaiah.
Yeah, I'm not reading that note. Then in para 77 onwards is general power of regulation and control does not include the power of tax. Please come to page 2123. Thus, the power to levy and collect fee or taxes in respect of minerals mined, quarried, excavated, or collected was expressly conferred by the on the central government by a specific provision made in that regard by the Act. Because the power to levy tax or fee was appropriated to itself by the central legislation, it was held that the impugned Odisha Act or state legislation could not have provided for the levy of a fee by virtue. Now they are dealing with the 48 Act, Hingir Rampur, 1948, which expressly had, at that time, constitution was not there. The union, having exercised its power to legislate, the field was covered and accepted from the legislative competence of the state, yet the recovery was held not liable to be annulled, inasmuch as Central Act 53 was a pre-constitution legislation and there was no declaration under. Then para 90, they say MMRD Act, which we are called upon to deal, stands on a much better footing for the writ petitioners herein, as it does not contain any provision similar to section 6 and 10 of the Central Act of 48 or section 9 of the Central Act of 1951. Then they go on to Tolak and all those. Your ships will kindly leave that for the moment. Kindly come to paragraph 97. Section 13(2)(I) cannot be read as empowering the central government to levy any tax or fee. The expression other fee and charges has to be interpreted as justem generis, taking color from the other words and phrases employed in the same clause. The word charges cannot and does not include within its meaning any tax. The expression other fee or charges must be assigned such meaning as to include therein only such fee and charges as are meant for regulation or development. We are clear in our minds that a power to levy tax or fee cannot be spelled out from section 13, 18 and 25 of the Act of 1957. It is well settled that power to tax cannot be inferred by implication. There must be a charging section specifically empowering the state to levy tax. Section 18(2)(q) speaks of a fee to be paid on applications for revision and not on mineral rights or mining land. Section 25 speaks of recovery of tax and fee amongst others. Two observations are spontaneous. Firstly, a provision for recovery being a machinery provision cannot be read as empowering the levy of tax or fee. Secondly, it speaks of tax or fee being due to government without defining the same and without qualifying the word government with central or state. A perusal of several provisions of the Act and in particular section 9A, 15, 15, 1A, 15.3, 17.3, 21.5, 25 goes to show that the power of recovery is invariably given to the state government. Obviously, the word government in section 25 refers to state government, which only is empowered to recover the sums due as arrears of land revenue. And then they deal with whether it can be located power of tax as a residuary power. Kindly come to para 104 at 2130. Power to tax must be express, else no power to tax. Para 104 to 107.
7 is important.
And at page 2135 in para 113, after referring to various other judgments,
Para?
just above para 114, the part of 113 at page 2135, placitum A. The power of levy tax is essentially for the very existence of the government, though its exercise may be controlled by constitutional provisions made in that behalf. Power of tax is not outside constitutional limitations. It is for Parliament to exercise power in the field made available to it by entries 52 and 54, list 1. It is also for Parliament to state by law the limitations and the sweep thereof, which it may choose to impose on the field available to the state for taxation by reference. into entry 50 list 2. It may not be for courts to venture into inquiry in just an individual case to find out and hold what tax would hamper mineral development if Parliament has chosen to observe silence but not legislating or fail to say something explicit. A reasonable tax or fee levied by state legislation cannot, in our opinion, be construed as trenching upon the union's power and freedom to regulate and control mines and minerals. In para 125 Goodrick case, no, there was another issue with the Baksa Dwar and Goodrick, which is correct. And then 129, Goodrick was held to be correctly decided in para 128. And this is important because here, the tax on the tea estates, on the dispatches, was on the dispatches, and therefore, and that was upheld. On applying the aforesaid principle, that's para 127, the court concluded that taxing the quantum of yield of a tea estate for measuring the amount of tax is perfectly valid and cannot be equated to the situation in India Cement. We may observe the reasoning adopted in Goodrick accords with the reasoning in Hingir Rampur. Was correctly decided. Then 129 summarizes those. So in the some of the written submissions, it was said not that if this tax is allowed, then the price of mineral will go up. Now, whenever tax is imposed, the prices do go up. But that will by itself be no ground, my lord, for saying that the tax is power is to be denied by stretching some language here or there and saying the power is out. Then the best thing would have been, my lord, to accept what was stated in the Constituent Assembly and shift entry 50 to the, which was rejected. And that is, if your lordship will find, volume 4A,
Page 16, at page 16.
at page 16,
Page 16.
volume 4A, page 16. Page 7 to 16, what is for it?
Page 10 page, entry 2. It is sitting on page 16.
Page 7.
Yeah, page 16. This entry 54.
What are you showing us, Mr.
Page
Yadav?
16 of that.
4A.
16.
What is the page?
Page 16 of volume 4.
Page 16, volume 4A, entry 5. This was draft entry 54 at that time, entry 50. He moved this amendment that entry 54 of list 2 be transferred to list 1. And in fact, he also said, earlier that even 23 should be not be there,
That's at page 10.
which is at page 10.
My whole aim in moving this amendment is to make it redundant.
And that was both were rejected.
This paragraph, page 10 is the relevant part, Mr. Dwivedi, of the assembly.
Page 10
constituent-
is for entry 23.
Is relevant, 16.
In entry 54 of list transferred to list 1, that one, is it?
Yes.
16, 52. That I was-
If your lordship looks at
52.
page 10 bottom, my whole aim in moving this amendment is to make redundant entry 28, which is 23 now of list 2. I'm clear in my own mind that mines constitute a vital subject as important as defense, foreign affairs, communications. I am of opinion that if system of defense is going to be organized on sound lines, then mines must remain in central subject. I do not want to give the provinces the power even to regulate mines and oil fields and mineral development subject to the provisions of list 1 as has been provided in entry 28.
Yes.
That was the submission.
And then rejected at page 16.
Yes. So both were rejected. So therefore the,
Land is something under the control of the state government.
yes, sir. So land could have still remained, therefore it's not about 49. It is about entry 23 list 2, which to start with says regulation of mines and mineral with the state. Then parliament makes a law, it shifts to the extent the parliamentary law provides under entry 54. So Mr. Prasad wanted that 23 should not be there at all.
At all.
Keep it with the list 1. And entry 50 also, he said, which was then draft article entry 54, that should also be there. It should not be with the state at all. But it was rejected. So the intent is that this taxing power should remain, but instead of transferring it, they kept the limitation.
Right.
So if the parliament wants, we have no problem. We are still conceding that as far as entry 50 is concerned, parliament can make an amendment in the existing law or any other law and provide limitations that you can't impose tax more than this, whatever limitation it wants. But it will have to spell out that it is doing so in order to limit entry 50 list 2. It's a very vital importance for the state's taxing power. So which can't be sub silentio by prescribing a fee or some royalties or surface rent, dead rent. You just take away sub silentio, a vital taxing power of the state.
Should be in the interest of mineral development. Only
That's also,
limitation can be
Yes,
only
so
in the
it's not-
interest of.
I'm grateful. It can't be just absolute that I don't want this to happen. They have to consciously consider that that is required in the interest of mineral development and not because of any extraneous considerations or reasons. So there is a limit on the limitation power itself.
Yeah, that's correct.
And some emphasis has to be given by the fact that this was specifically moved to bring it within the ambit of
Right.
the union list.
That's right.
But then that was specifically rejected by saying it will remain with the state list. So the debate in the Constituent Assembly and the thought process then will have to be given some meaning
Yes, right.
and some emphasis.
It's a very important aspect because the easiest thing for the framers was, they were the people who were framing. They could have just shifted it. And I don't think anybody would have objected much, maybe for minor minerals, there would have been some voices.
Objections solicited.
This in Kesharam, they consider specific matters, coal, tea, etc. For the time being, I'm not adverting to that.
The making a point, I think, which is relevant.
Yes,
Union does not have a land of its own. It's a union of states. The states are owning the land.
yes,
So
it
if
has
you want to do some exploitation,
that's right.
so
So it will have land lot in union territories,
that's
and
that's
it can have land by acquisition, as in Coal Bearing Acquisition Act, they have acquired the land,
That is by acquisition.
acquisition.
Otherwise, the
To start with, no, yeah, Malus are right.
land is with the state.
Yes.
or you have to travel to the sea.
So Malus, India was being united.
Yes.
Each states, there were pulls, pressures, compromises of all sorts. The framing of the constitution is a complex exercise involving a large number of compromises. So everything has to be adjusted.
Said that our constitution is federal in structure and unitary in spirit.
Yes. It has so many areas where it can acquire a larger domain than what is expected. But the problems were very, very complicated.
Done now?
No, Malus. Just coming to the close.
Tell me that, we don't have a clock which faces us, but I have a clock facing me.
That's why we don't face the clock. We only look to your lordship. Benevolence. The matter is rather important, not for states, even for the other side.
Enforced while a point is at
And keeping in view the history, this twists and turns, it has to be.
The next part.
366/28 is read.
Now kindly have a look at Hingir Rampur for the moment. Justice Vanchu's judgment. Because of some reasons, he deployed entry 84 to knock out the tax on mineral rights.
Mr. Dwivedi, you have not taken a break since the morning, since 10:30.
Yes.
We'll offer you to take a break. We'll ask your junior to tell us what the facts of Hingir Rampur are.
Yes.
Just
All right.
take a break and have a glass of water.
All right.
She's so well prepared. Ma'am, you tell us what Hingir Rampur is.
Your lordships, in case of Hingir Rampur, your lordships,
Where do we find Hingir
your
Rampur?
lordships, the dissenting judgment is at 172, my lords, volume 5.
Volume 5.
Page 172 is the relevant paragraph 53, which has been relied, my lords.
Just 1 second.
Volume 5.
Volume 5 page.
What?
Sanskriti Pathak, my lords.
Sanskriti.
Sanskriti Pathak.
So confidential. Take.
My lords, in this, the argument
Paragraph
53.
53. Just 1 second. Yes. Just read it out and then you can make your point.
The next contention on behalf of State of Orissa is that if the cess is not justified as a fee, it is a tax under entry 50 list 2 of the 7th schedule. Item 50 provides for taxes on mineral rights subject to any limitations imposed by the Parliament by law relating to mineral development. This raises the question as to what are the taxes on mineral rights. Obviously, taxes on mineral rights must be different from taxes on goods produced in the nature of duties of excise. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under item 84 of list 1. A comparison of list 1 and list 2 of the 7th schedule shows that the same tax is not put both in both the lists. Therefore, taxes on mineral rights must be different from the duties of excise, which are taxes on minerals produced. The difference can be understood if one sees that before minerals are extracted and become liable to duties of excise, somebody got to work the mines. the usual method of working them is for the owner of the mine to grant mining leases to those who have got the capital to work the mines. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. Thus, tax on mineral rights would be confined, for example, to tax on leases of mineral rights and would be on premium or royalty for that. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on minerals actually extracted would be duties of excise. It is said that there may be cases where the owner himself extracts minerals and does not give any right of extraction to somebody else, and that in such case, in the absence of mining leases or subleases, there would be no way of levying tax on mineral rights. It is enough to say that these cases also, rare though they are, present no difficulty. Take the case of taxes on annual value of buildings. Where there is a lease of the building, the annual value is determined by the lease money, but there are many cases where owners themselves live in buildings. In such cases also, taxes on buildings are levied on the annual value worked out according to the certain rules. There would be no difficulty where an owner himself works the mine to value the mineral rights on the same principle on which leases of mineral rights are made, and then to tax the royalty which, for example, the owner might have got if instead of working the mine himself, he had leased it out to somebody else. There can be no doubt, therefore, that the taxes on mineral rights and taxes of this nature and taxes on minerals actually produced. Therefore, the present cess is not tax on mineral rights. It is a tax on minerals actually produced and can be no different in pith and substance from a tax on goods produced, which comes under entry 84 as duty of excise. The present levy, therefore, under section 4 of the Act cannot be justified as a tax on mineral rights, my lords. My lords, in this case, the argument was there was a fee which was being levied on the mineral dispatches. First, they have dealt, my lords, with the fee, but on the tax part, Justice Vanchu in his dissenting judgment draws a distinction between the mineral produce and the right of giving lease, which is mineral rights, my lords, which to my understanding, my lords, is an incorrect interpretation. As Mr. Dwivedi said, mineral right would include extraction, sale, consumption, all aspects. And so far as taxation principles are concerned, my lords, different aspects. Manufacturing, yes, manufacturing will entail excise duty, my lords. But once it is being sold, it will attract VAT. So that is another aspect, which the state is competent to levy. Then mineral right, my lords, will include extraction, sale. So that would come in entry 50, my lords.
Just one second. So how are you formulating it? Just formulate it again, please, for us.
My lords, the artificial distinction drawn in para 53.
Just go a little slow. The artificial
distinction drawn between the mineral produce and the mineral right, which is confined to right to lease or royalty.
One second. Between the mineral produced and
the mineral right, that is right to lease or royalty, is a narrow and restricted interpretation of the expression mineral rights in entry 50.
This one. Yes.
So entry 50, my lords, cannot be limited to right to grant lease and royalty. State under...
Just one second. Cannot be restricted
to right to grant lease or royalty. The expression mineral right is a comprehensive term which will include the extraction of mineral produce.
Just one thing. It will include extraction.
The mineral produce itself, the extraction thereof, consumption thereof, sale of mineral produce, and the right to grant lease. So it's a comprehensive term. Mineral produce cannot be extracted from entry 50. So this is where, my lords, this para has gone wrong, my lords, and has been subsequently followed in all the judgments.
Thank you. Thank you, Francis.
There is one more.
I hope you agree with what is.
Yes. Yes.
Yeah, very well put, actually. We must compliment your junior.
Definitely.
We've all three have been saying that. That's why I said, we'll
Yes. And
get Sanskrit
great.
to make.
Very pithily,
There's one more fundamental error here.
very pithily submitted.
Yes.
Yes.
There's one more. There's one more fundamental error. Justice Vanchu holds that tax, assuming he's right on the distinction, that mineral right is extraction, but not the mineral. And from that, he concludes that since the tax is on mineral, therefore it's falling under entry 84. Entry 84 list 1 is excise duty.
Right.
And the taxable event of excise duty is manufacture, not the good itself. So therefore, even if it is, the incidence is falling on the mineral, entry 84 is not tax on goods. Luxury tax also. In the case of Godfrey Phillips, Constitution Bench, what was an issue was entry 62 luxury tax.
Justice Venkatachala judgment, right?
This is volume 5, page 2267. And Odisha High Court, my lord, in this judgment has just followed that dissenting judgment as approved in India Cement, and it is said it is not departed expressly in Kesharam, and therefore larger bench, and we will follow. That's how they. So tax on luxury was under entry 62 was an issue. And prior to this judgment, all states were imposing taxes on refrigerators and luxury cars and various other luxury items. And this was a case where luxury tax was imposed on tobacco, cigarettes. The contention was that tax has been imposed on cigarette as goods, whereas entry 84 is there. And if the two entries are understood as being covering tax on goods, then there will be overlap and conflict. So therefore, entry 62 will not include tax on goods. If your lordship has para 54 at page 2295. The argument of, lordship has para 54. The argument of the SSEs is that the tax levied under entry 62 list 2 cannot be a tax on goods, as that would not only allow the state to levy sales tax in contravention of Article 286, but would permit trespass on the union's legislative fields under entry 83 and 84 of list 1. Indeed, the contention of the SSEs is that the states have the impugned legislations done just that. Entry 83 and 84, then their 84 is extracted. 55, the states have countered this by contending that entry 62 list 2 envisaged a tax on luxury goods, whereas duties of excise custom sales are not directly on the goods but with reference to goods, and that the taxes are leviable on the event of manufacture. import, export and sale according to the states, this court has held so while construing Article 289(1) in Bill to amend Section 20 of the Sea Customs Act. The taxable event in the case of duties of excise is the manufacture of goods and duties not directly on the goods but on the manufacturer. We may, in this connection, contrast sales tax, which is also imposed with reference to goods sold, where the taxable event is the act of sale. Therefore, though both excise duty and sales tax are levied with reference to goods, the two are very different imposts. In one case, the imposition is on the act of manufacture or production, while in the other, it is on the act of sale. In neither case, therefore, can it be said that the excise duty or sales tax is a tax directly on the goods, for in the event, they will really become the same tax. It would thus appear the duties of excise partake of the nature of indirect taxes as known to standard works on economics and are to be distinguished from direct taxes like taxes on property and income. Similarly, in the case of duties of customs, including export duties, we can leave that one. Now, this submission.
Para 59.
Yes. The logical corollary of holding the taxes are imposed only on taxable events is that even when an entry speaks of a levy of tax on goods, it does not include the right to impose taxes on taxable events, which have been separately provided for under other taxes and entries. The tax in respect of goods has sometimes been referred to as a tax on an aspect of the goods. So this doctrine of aspects is well accepted and entrenched under the Constitution. Sometimes as the taxable event. What the terminology, because there can be no overlapping in the field of taxation, such a tax, if specifically provided for under one legislative entry, effectively narrows the fields of taxation available under other related entries. It is also natural when considering the ambit of an express power in relation to unspecified residuary power to give a broad interpretation to the former at the expense of the latter. For example, the state cannot, under the garb of luxury tax under 62 list 2, impinge on the exclusive power of the union under 83 and 84 of list 1 by merely describing an article as a luxury. Of course, the states do have the exclusive power under entry 54 list 2 to legislate with respect to taxes on the sale and purchase of goods other than newspapers, but the power has been expressly made subject to the provisions of 92A. Apart from the limitations, etc., then 286 is 3 is referred to, and para 61 talks about the power to the Parliament's power to limit. And in this case, the limitation has been put at 4%. This is one illustration of how Parliament can expressly provide for a limitation. Finally, come to para 72. In view of the decision in Sea Customs Act case, the second premise propounded by Mr. Salve is unacceptable. As we have seen in that case, this court held that taxable event ownership is implicit in the concept of tax on goods. That the entries on taxable events in the legislative lists are not exhaustive is also recognized and provided for in Article 248(2), which provides for power of Parliament to make any law imposing tax on mentioned in either the current, concurrent or state list. This residuary power is reflected in entry 97 list 1. Furthermore, if an article or goods are taxable only with respect to a taxable event, and if, as contended by Mr. Salve, all taxable events have been provided for in different legislative heads, then by that token, no object or goods could be taxable. This would render the various entries in the state list, including entry 57 and 58, contentless, as we cannot accept that the taxation entries exhaustively enumerate all taxable events. It does not follow that entry 62 of list 2 does not cover goods. It is not possible, therefore, to hold merely on such a construction of the legislative list and the taxation entries therein, that entry 62 list 2 does not permit the states to levy tax. Having rejected the second premise contended for by Mr. Salve, the next question is whether the language of 62 would resolve the issue. So on this aspect of conflict, we were able to deal with the contention, but we lost on another ground, which may have, that is on a plain construction of the entry itself. The court said that luxuries will not be on the goods, but on the act of entertainment, etc., which happens. It could be on smoking, not the cigarette. Para 75 onwards,
And
the
then para
doctrine of
93.
nociter associis was applied to constitutional entry. Para 77 may be seen. We contended that is a very treacherous doctrine to deploy. In the present context, the general meaning of luxury has been explained or clarified, must be understood in a sense analogous to that of the less general words such as entertainments and amusements, gamblings and betting, which are clubbed with it. The principle of interpretation known as nociter associis has received approval in Rainbow Steels, although doubted in its indiscriminate application in State of Bombay versus Hospital Mazdoor Sabha. In the latter case, this court was required to construe 2J of the Industrial Dispute Acts, which read industry means so-and-so and includes any calling, service, employment. It was found that the words in the definition were of very wide and definite import. It was suggested that these words should be read in a restricted sense, having regard to the concluded item on the principle of nociter associis. The suggestion was rejected in the following language. It must be borne in mind that nociter associis is merely a rule of construction, cannot prevail in cases where it is clear that the wider words have been deliberately used in order to make the scope of defined words correspondingly wider. It is only where the intention of the legislature in associating wider words with the words of narrower significance is doubtful, otherwise not clear, that the present rule of construction can be usefully applied. It can also be applied where the meaning of words of wider import is doubtful, but where the object of the legislature in using wider words is clear and free of ambiguity. The rule of construction in question cannot be pressed. We do not read this passage as excluding the application of principle of nociter associis to the present case, since it has been amply demonstrative the reference to authority to the meaning of the word luxury in entry 62 is doubtful and has been defined and construed in different cases. So by this, deploying this doctrine, it was held that it will not include, entry will not include the goods.
Para 93, they said.
Yes.
Because we saying it is not either, it will not fall under 28, it is not an impost.
So this doctrine, Lord, which I am invoking, Lord, for purposes of understanding the word impost. Now, taxation includes tax and impost. Now, first word is including, which suggests expansive. But the domain is taxation. It is the word taxation and tax which is being defined. There is an element of tautology involved, Lord. Tax means tax and impost. Taxation includes tax and impost. So the very word which is being defined will circumscribe what is being included. The character of the impost, therefore, has to be necessarily of the nature of tax. In para 33, we have referred to two cases on impost. Lashmi just noted in para 33. Now, just 2 or 3 cases on this limitation aspect. I had shown that entry 57 is similar, that there is a page 53 of the written submission. If your lordship turns, my lord, some paragraphs have been extracted also there.
Page 53.
Yes. There's a caption of entry 57. 57 is extracted, 35 is extracted. In state of Assam, that's para 113.
Just one second. Volume 1A, right?
This is fine. We're not citing. Volume 1A. Permission is granted.
Volume 1A.
Yes.
Yes. 1A, volume 1A, page 53, para 113. In state of Assam versus Labania Prabha Devi, AIR 1967. This honorable court, while dealing with a challenge to Assam Motor Vehicles Taxation Act, held that the two entries deal with two different matters, though allied. One deals with taxes and the other deals with the principles on which, I'm sorry, Lord Justice Nagar,
Yes, I have it.
at the bottom, are to be levied. The court upheld the law amending the schedule by which the rates of taxes were increased. Paragraph 11. The short question, therefore, is whether any of the provisions of the amending act is repugnant to any of the provisions of the existing law with respect to any of the matters enumerated in the concurrent list. Under the existing law, that is Act 9 of 36, no motor vehicles could be used in Assam province unless the owner thereof had paid in respect of it a tax at the appropriate rate specified in the schedule to the act, and save as therein specified. Such a tax should thereafter be payable annually, notwithstanding that the motor vehicle might from time to time cease to be used. As aforesaid, the schedule annexed to the principal act was amended from time to time by different amending acts, and the rate was increased. Under the 1963 Amendment Act, apart from other provisions which do not relate to any principle of taxation, a new schedule has been substituted. Neither the amending act nor the schedule laid down any principles of taxation in respect of motor vehicles. So too, the amending act 66 substituted the schedule of the act by another schedule A. A perusal of the aforesaid schedule only discloses that different rates were fixed. That is to say, the amended schedule does not lay down any principle on which taxes on motor vehicles are to be levied within the meaning of entry 35 list. 3. A concurrent list. It is solely concerned with taxes on vehicles within the meaning of entry 57 list 2. The two entries deal with two different matters, though allied ones. One deals with taxes on vehicles and the other with the principles on which the taxes are to be levied. When two entries in the Constitution, whether in the same list or different list, deal with two subjects, if possible, an attempt shall be made to harmonize them rather than to bring them into conflict. Taxes on vehicles in their ordinary meaning connote the liability to pay taxes at the rate at which taxes are to be levied. On the other hand, the expression principles of taxation denotes rules of guidance in the matter of taxation. We therefore hold that the amending acts do not come into conflict with the existing law. A similar view was held in Jairam's case. It is true that the object of enacting Section 63(7) by the Parliament was to promote all India and interstate tourist traffic. But taxes on vehicles suitable for use on road is a state legislative subject, and it is for the state legislature to impose a levy and to exempt from the levy. True, again, entry 57 of the state list is subject to entry 35 of concurrent list, and as explained by us at the outset, it is therefore open to Parliament to lay down the principles on which taxes may be levied on mechanically propelled vehicles. But the Parliament, while enacting Section 63(7) of the Motor Vehicles Act, refrained from indicating any such principle, either expressly or by necessary implication. The state's power to tax and to exempt was left uninhibited. It may be that the state legislation, plenary or subordinate, which exempts non-home state tourist vehicles from tax, would be advancing the object of Section 63(7) of the Motor Vehicles Act and accelerating interstate trade, commerce, and intercourse. But merely by Parliament legislating Section 63(7), the state legislatures are not obliged to fall in line and to so arrange their tax laws as to advance the object of 63(7), be it ever so desirable. State is obliged neither to grant an exemption nor to perpetuate an exemption once granted. This was reiterated in Sharma Transport. Power to levy taxes on vehicles, whether mechanically propelled or not, vests solely in the state legislature, though it may be open to Parliament to lay down the principles on which taxation may be levied or on mechanically propelled vehicles in the background of entry 35. To put it differently, Parliament may lay down the guidelines for the levy of taxes on such vehicles, but the right to levy in taxes vests solely in the state legislature. No principles admittedly having been formulated by Parliament in that sense, the Government of India's communication dated 30th of August 1993 does not in any sense violate the power of state legislature or its delegate to levy or exempt taxes from time to time. Then the next paragraph also may be seen, that's about the limiting power under 286(3). And I've referred to Rajasthan Roller Flour Mills Association. Okay, kindly have volume 5C. Volume 5C, page 97.
C, ka?
Rajasthan.
Volume 5C, page 97 at page 103.
Yes.
What I want to emphasize is the few words in placetum D. We are therefore, just below that, placetum D, we are therefore inclined to agree with the Learned Counsel for the states that the provisions of section 14 and 15 of the Act, being restrictions upon the plenary power of the state legislature to levy tax on sale or purchase, must be construed strictly. So there can't be a sub silentio exercise. Please have 21 also. In our opinion, the restrictions upon the legislative power of the states provided by section 1415 read with clause 3 of article 286 must similarly be construed strictly. Therefore, commodities other than those specified cannot be introduced into relevant provisions on the ground that they are derived from the primary commodities mentioned in 14.1. So under 14, they can specify goods of national importance, special importance, in which event the Parliament gets then entitlement to impose by law restrictions. The said clause refers to certain primary commodities. The goods produced or manufactured out of them cannot be included in those commodities. Otherwise, problem of where to draw the line would also arise. Maybe that part of the tax collected on state is ultimately made over to the states in contemplated 269. But that aspect has no relevance to the question of power of the state legislature. So when an entry is to be shut out or limited, there must be express reference to entry 50 list 2 that they are doing it with in order to attain that objective. Just hold on. So that's with regard to the limitation. The only issue, my lord, is as far as land, I have already referred exhaustively. The cases on land have been referred to, but in our written submission, page 26 to 35. In every case, the entry has been construed broadly. With reference to other entries, something cannot be taken out. In this context, if your lordship also notes the entry in the constitution with regard to cultivation of opium.
So small water.
That's entry 59. Cultivation, manufacture and sale for export of opium. Now this may dilute the entry of agriculture in list 2. Squarely dealing with cultivation of opium, but it will not. It's not dealing with the land on which opium is being cultivated. So therefore, entry 18 and 49 would not be impacted. Now, the only other submission which remains is, my lord, that entry 50 is special and entry 49 is general. Therefore, entry 50 will be out of the fold of 49. Is one of the submissions which I find, my lord, on the other side. It is also said that Keshav does not specify clearly as to whether this the tax which was impugned will fall under 49 or will fall under 50. The court said the two entries are there, which I submit is a correct approach. But if both are the powers of the state, then it matters little, not whether this or that or both taken together. If there is something, a mix of the two, it hardly matters.
So that principle of rag-bag legislation can apply where the state, it's not only in relation to the union list.
Yes.
Because if the state has the power both under entry 50 of list 2 and entry 49, can combine both
Yes.
your power under both the entries.
So just as in the case of parliament, this court has said that if the parliamentary law is challenged, one has to simply see whether it is covered by list 1 or 3. Once that is so, matter ends. Question of conflict, etc. doesn't arise.
Because of entry 97.
But when legislation is involved, then one has to see whether any entry taken isolatedly or along with other entries in the state list support it. If it supports, then the only other question will be, is it clashing with anything which Parliament may have done with respect to the entries? Is there a clash between the entries then? Which ordinarily this court doesn't come to that conclusion straight away that there is a conflict easily. It's a last resort. First of all, doctrine of harmonious construction will come in, court will chisel this, chisel that, see that there is some scope in both the entries. None of them are rendered ocious. That's how the court approaches.
But you're not relying on entry 49.
We are relying on 49, it's squarely a tax on land, and annual value has been taken, which your lordships have seen in Keshav Ram, that annual value can be, and it does not matter.
It is more on entry 50.
It's a tax on land, and I'm saying that merely because the measure of tax is on the value of the minerals, that does not make it a tax on mineral rights. That's the first submission. This remains a tax on land. The value of mineral can be a measure for both the entries. Just as income can be, my lord, a basis, a valid measure for various entries. It can be a measure in the capital asset, it can be a measure in the tax of income, it can be for tax on land and building. So the measure therefore should start with, one doesn't start with the measure and then determine the character. If the state is saying that it's a tax on land and the measure has nexus, that's the principle.
So even if the measure is the quantum, the mineral extracted,
These are all connected with the land. But for the land, this cannot be had. And it is on that land we are imposing. Can we have the measure of annual value of the minerals for that? Or by deploying that measure, we are changing the character and trespassing into the field of entry 50. So to start with, my submission is that the fact that the impugned legislation in the case of Odisha and other states, not Jharkhand. Jharkhand is simply per square meter of land. So Jharkhand is completely outside, not squarely on land. Entry 49.
like that Odisha legislation, you are saying something.
Odisha legislation and some other states which have designed their statute based on Keshav Ram, they have deployed the annual value of the minerals dispatched. So the product of the land and the land, they have intricate and direct connection. Every product which emerges out of land, be it on account of the effort of the farmer or manufacturer, or a producer who is engaged in mining, connect cannot be said to be remote, far removed. The connect is proximate and the value is relevant. The nexus is proximate and direct. So it's a tax on land. Secondly, the tussle between our own entry is arising because the other side feels that by bringing in entry 50 list 2, the authority of the parliament then to limit the tax arises. That's the reason. But there was no motion moved in the House that entry 49 for this reason. They could have easily said tax on mining land also, put it in the fold of parliament. They don't remove any kind of land from the fold of entry 49.
The question is whether a tax on mineral right is a tax on land per
So
se.
our act is not saying, Lord, it's a tax on mineral right. It is because of the measure alone that they say it is tax on it. Our acts are clearly saying that it's a tax on mineral bearing land.
Then you are saying the limitation stated under entry 50 would not apply?
That's right. 50 doesn't come in because 50 doesn't deal with land.
59.
Submissions were made in the earlier cases also.
In Kesharam also, that was the plea which
Earlier
has
in
been,
older cases also, I think.
Sorry?
In HRSR Murthy and all that.
they also accept a tax on land. HRS Murthy is a constitution bench, they accepted it's a tax on land.
Are you saying, Mr. Dwivedi, that because the tax is on mineral bearing land, therefore entry 23 of list 1 does not impose any restraint?
There's no power then to limit it.
I'll just pose a question after lunch, because then the point really is only this. If a tax is a tax on land per se, then obviously entry 23 of list 1 does not impose any fetters. But if the tax on land is, albeit a tax on mineral bearing land, can we then not postulate, can it not be postulated that the levy of this tax will have some impact on the development of minerals?
So, my lord,
And if so, would it not be open to Parliament to prescribe limitations, even though you are really seeking to exercise your power under entry 49? True, entry 49 of list 2, we have to bear that in mind. Entry 49 of list 2 is not made expressly subject to entry 23 of list
Yeah.
1. But where you are choosing to levy the tax on mineral bearing land, your point that, the annual value is the measure of the tax, that's fine, no difficulty. But if you are choosing to impose a tax on mineral bearing land, is it not open to Parliament in exercise of its power under entry 23 of list 1 to impose restraints or limitations even when you are exercising
if
the
I
power under-
understand, the lordship says that even though those expressions subject to limitation, etc., is not there in 49, yet because of entry 54, some limitation could still be imposed on 49.
When you choose to tax not
Mineral bearing
land
land.
generally as a unit, but mineral bearing land as a unit.
I follow. I'll respond.
Yes.
That hypothetical would arise in the next case where Andhra has specifically taxed mineral bearing and placement.
In almost every case, there is
Almost
tax on
every
mineral
case,
bearing land
right.
and other land also.
That's right.
With regard to other land, this problem will
We'll
not
come
arise.
back up.
Yes.